what people are talking about. In recent months, debates over how courts establish and record jurisdiction have intensified. Commentators and practitioners are pointing to a pattern. Modern courts rely more heavily on statutory presumptions, procedural entries, and rapid emergency orders to assert jurisdictional power. This conversation centers on whether those mechanics shift the real burden to defendants, who must displace presumptions in often compressed timeframes, and whether abbreviated rulings on the so-called shadow docket function as de facto jurisdictional declarations. The question is doctrinal and practical. When does the record truly prove jurisdiction, and when does the record merely create a momentum that is very difficult for defendants to undo? This segment frames that tension and why it matters for rights, process, and the allocation of burdens in litigation. The paper trail that underlies this topic is rich and specific. Start with Bard Justice's essay, The Jurisdictional House of Cards, SRC 2A2105F9A5, which assembles a theory about how statutory presumptions and procedural habits combine to generate a fragile but effective structure of contested jurisdiction. That piece should be read alongside the foundational cases that define the doctrine. Pennoyer v. Neff, 95 U.S. 714, 1878, which articulated the territorial and service-centered conception of jurisdiction in the 19th century, and International Shoe Co. v. Washington, 326 U.S. 310, 1945, which displaced a rigid territorial rule with the modern minimum contacts due process standard. On the rules side, study Federal Rules of Civil Procedure Rule 12b-1, motions to dismiss for lack of subject matter jurisdiction, and Rule 12b-2, motions to dismiss for lack of personal jurisdiction. Those rules set the procedural pathways for jurisdictional challenges and describe timing and waiver consequences that petitioners rely upon. For concrete modern examples, examine Margolin v. NAIJ, Court Listener Slip Opinion, Court Listener ID 108641990, www.courtlistener.com/opinion/108641990/Margolin v. Jive. That slip opinion illustrates how a rapid appellate entry can resolve or postpone jurisdictional questions in a way that downstream courts and litigants treat as presumptively authoritative. Complement this with contemporaneous records of Supreme Court emergency docket activity and shorter slip orders. Many of those entries are tracked on Court Listener and summarized in secondary coverage. A helpful analytical resource is SCOTUS Blog's recent piece, How Often Do Courts Actually Cite Emergency Docket Orders, May 28, 2026, which compiles data and examples of how emergency or shadow docket orders are recorded, cited, and relied upon by lower courts. Finally, to trace the mechanics, consult local court docket entries in representative cases, service returns, default judgments, motions to set aside, and the underlying factual showings that courts accept or reject when deciding whether the record supplies jurisdiction. Those primary filings, summons, service affidavits, motions under Rule 12, evidentiary submissions on factual jurisdictional contests, are the evidentiary bedrock that produces presumptions in subsequent rulings. Public versus private capacity and rights versus privileges lie at the heart of any jurisdictional inquiry. Jurisdiction is fundamentally a claim of public power, a court asserting the authority to bind persons or property. But that assertion is sustained through a combination of statutory license, for example, long-arm statutes that grant personal jurisdiction under specified contacts, and private procedural acts, service of process, consent in a contract, or a party's appearance. Because courts treat some of those procedural acts as prima facie proof of jurisdiction, the presumptive posture can look like a default transfer of the burden from plaintiff to defendant. Historically, Pennoyer required physical presence or property within the forum for the state's reach to be valid. International Shoe reoriented the inquiry to fairness. Do the defendant's contacts with the forum make exercise of jurisdiction reasonable? That doctrinal shift opened space for statutory presumptions and procedural shortcuts to occupy more of the adjudicative field. Minimum contacts is necessarily fact-intensive, but in routine practice, courts often treat a return of service, a signed waiver, or a statutory citation as sufficient record to proceed. The result, a plaintiff who files a complaint and attaches standard process forms can generate an initial presumption that jurisdiction exists. The burden then falls on the defendant to disprove that presumption, typically through a timely Rule 12b2 or Rule 12b1 motion, often supported by affidavits and jurisdictional fact statements. The procedural timing rules matter. Rule 12's waiver and timing provisions mean that failure to raise a jurisdictional objection promptly can result in forfeiture. Subject matter jurisdiction presents a technical exception. Courts say it can be raised at any time because the court cannot adjudicate without it. But in practice, the contours of that principle can be narrowed when courts accept preliminary records as affirming subject matter posture. For example, when statutory grant of jurisdiction is evident on the face of the complaint, or when an emergency or interlocutory order treats the question as settled for immediate purposes. That is one axis where the burden shifts. Plaintiffs need only produce a record that satisfies prima facie predicates. Defendants must mount timely, sometimes expedited, proof to the contrary. The so-called shadow docket compounds this dynamic. Emergency orders, stay applications, and other abbreviated entries frequently resolve immediate questions with little or no published reasoning. On high court dockets, these orders can be issued single-page and per curiam. They may state a disposition without full explanation. When lower courts see a high court emergency order or a fast slip ruling that favors one party's procedural posture, those entries can be cited as persuasive and practically dispositive, even though they lack reasoned analysis. SCOTUSblog's recent empirical work shows that emergency docket orders are cited with surprising frequency, and many lower court practitioners now treat such entries as a kind of provisional authority. This creates a two-tiered evidentiary life cycle. First, a rapid procedural entry establishes momentum. Second, that procedural momentum becomes a presumptive fact in subsequent proceedings unless a litigant can successfully, and often quickly, overcome it. This dynamic has material consequences for private rights. Consider waiver. Appearance in a case may be made either in a private capacity, an individual responding as a person, or in a public or representative capacity, an officer answering for a corporate entity or as an agent. Service on a corporate agent can be argued to bind the corporation in its commercial capacity. Service on an individual may implicate individual constitutional rights. Courts sometimes treat representations by counsel, an appearance, a concession in briefing, or procedural stipulation as transformative. Consenting to jurisdiction in one capacity may not waive rights in another, but practitioners must be precise. Where the record is shorthand, a docket notation, a per curiam emergency order, a return of service, the lines between consent, waiver, and involuntary exposure blur. The defendant may retain a substantive right not to be bound, but practically, enforcing that right requires dislodging the procedural presumption the record has already created. Another important layer is the difference between rights and privileges. The authority of a court to adjudicate is a public power, not a private contract term. Yet many jurisdictional questions are litigated through contractual forum selection clauses or consent to suit. When parties contractually accept a forum, they convert a public exercise into a negotiated private waiver. Conversely, when a defendant is sued without any contractual consent, the court's authority depends on public law predicates and adequate notice. Statutes that create presumptions, long-arm laws, statutory service methods, or rules allowing constructive service in certain circumstances, attempt to bridge that gap by authorizing procedures that produce a record. But those statutes do not rewrite constitutional constraints. They only shape the documentary proof courts will accept as creating a presumption. Finally, consider evidentiary standards. In a factual attack on jurisdiction under Rule 12b1, courts may consider affidavits and other evidence and decide contested facts. The plaintiff bears the burden of demonstrating jurisdiction by a preponderance when facts are disputed. In contrast, when the attack is facial, courts take the complaint's allegations as true. That technical distinction becomes crucial in the compressed times of emergency motions. Emergency orders sometimes treat the attack as facial or deferred for later evidentiary determination, thereby preserving a plaintiff's presumptive record while pushing an evidentiary contest off the immediate calendar. From a practical perspective, that deferral imposes a heavy cost on defendants. To keep the issue alive, they must move quickly, often without the full discovery or evidentiary tools they would otherwise seek. The upshot is not merely doctrinal hair-splitting, where courts rely on procedural records and rapid emergency entries to assert jurisdiction. Defendants often face a stack of presumptive facts that require swift, precise responses. That increases litigation costs and can impair substantive rights, especially for parties who lack resources to mount immediate challenges. It also places a premium on docket management. Careful record-keeping, early jurisdictional affidavits, and an understanding of how emergency orders will be recorded and cited can make the difference between preserving a right and losing it by procedural momentum. If you want to investigate this further, here are concrete questions and primary documents to examine yourself. 1. Read Barred Justice, the Jurisdictional House of Cards, Esser Card C-2A2105F95. Ask, what mechanisms does the author identify that convert procedural entries into presumptions of jurisdiction? Identify the specific statutory or rule-based predicates cited. 2. Study the doctrinal foundations. Pennoyer v. Neff, 95 U.S. 714, 1878, and International Schuko v. Washington, 326 U.S. 310, 1945. How did the court's reasoning shift the emphasis from presence to contacts, and what language in International Schu permits a presumption based on record evidence? 3. Read Federal Rules of Civil Procedure Rule 12b1 and Rule 12b2. Note the timing and waiver language. Then pull representative motions to dismiss on jurisdiction from federal dockets to see how courts treat facial versus factual attacks. 4. Open Margolin v. NAIJ, Court Listener Slip Opinion. Court Listener ID 1del864190. courtlisten.courtlistener.canyon/190/Margolin-VNAJ. Trace the sequence of filings, complaint, service return, any emergency motions, the slip opinion itself, and subsequent citing opinions. Ask whether the slip opinion resolved jurisdictional facts or treated the question as deferred. 5. Consult SCOTUS blog's empirical work on the emergency or shadow docket. How often do courts actually cite emergency docket orders? May 28, 2026. And use Court Listener's slip order RSS feeds to compile a list of emergency entries over a chosen period. Then search Westlaw Google Scholar for lower court citations to those emergency orders. 6. Examine long-arm statutes and service of process statutes in several jurisdictions. Identify statutory presumptions, for example, constructive service on non-residents, and compare how lower courts apply those statutes in practice. 7. Finally, inspect specific docket sequences where jurisdiction was later overturned or where jurisdictional objections were found to have been waived. Ask what record entries produced the initial presumption and which filings ultimately overcame it. That empirical tracing will illuminate whether the burden truly rests on plaintiffs to prove jurisdiction or whether routine procedural practice has effectively shifted the burden to defendants. These paths will help you verify the theory, measure the practical effect on litigants, and form your own conclusions about whether the modern jurisdictional edifice is a house of law, a house of cards, or some mix of both. As always, check the primary documents listed here for yourself before drawing any conclusions. Spread the light of your divinity. Seek the truth. Law and logic must go.
Tipsy, tipsy, tipsy. Them politicians, them gone crazy. Drunk off the wine of greed and vanity. Forget about the people and the family. Tipsy, tipsy, tipsy. Them politicians, them gone crazy. Sick corruption, chase it with dishonesty. Trip over justice, fall upon inequality.